Morning.
All right. The welcome floor is now accepted. Our no chief trustee property for the cover.
Morning.
You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA23-002, People of Guam Plaintiff Appellee versus Gilberto Florenda Kusterbeck, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Peter C. Perez. Appearing for the Plaintiff Appellee is Attorney Christine Santos Tenorio. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Perez reserves 7 minutes.
You may proceed, Mr. Perez.
Good morning, Chief Justice Torres, and may it please the court. The worst, most dangerous defendant to be in a Guam court case is a defendant in a criminal sexual conduct case, especially where the alleged victim is a minor. Because when that occurs, you're presumed guilty, you're treated as guilty, and you're convicted in cases where an alleged victim doesn't satisfy the elements of the offenses, and where hearsay is freely admitted and third parties with no personal knowledge talk about the truth of the allegations.
Before we delve into the substantive arguments, I want to clarify the standard of review that we will examine for the sufficiency of the evidence. There was not a motion for acquittal down below, right?
Correct.
And so there was no objection to the sufficiency of the evidence at the trial level. So why is our standard, in your opening brief, you had argued it was a de novo review, but why doesn't the plain error standard apply since there was no motion for a judgment of acquittal?
I think the plain error standard of review does apply on the issue of sufficiency of the evidence. As to the issue of variance, it would be there are three different standards of review that I think affect the issue of the time element. One is sufficiency, which would be plain error. And then as to if there's a variance between what was charged and what was proved, it would be reversible error. If it dealt with a lack of unanimity, that was structural error, it would require automatic reversal.
Yeah.
Otherwise, it would be harmless error. But as to sufficiency itself, it would be plain error.
I didn't quite understand the argument you were making on the structural aspect of the. You said that because there was an overlapping time frame from the first charge and the second charge of January 1 and August 1 and April 1 and December 1, 2018. And then the referral to the first incident, second incident, but there were really 3 incidents that somehow it deprived him of a right to a unanimous jury verdict and was structural error. Can you elucidate that a little bit more? I didn't quite understand the point you were trying to make with regards to that.
Sure. So let me start by talking about the evidence. So we had the alleged victim, who I argued was unable to establish specifics regarding time frame. And when I say specifics, I don't mean exact. I mean she wasn't able to just to testify to time frame. We had
Didn't she testify though that at least the first time happened when she was living in Santa Rita, the second when she was in the second or third grade, and the last when she lived in the orange house around the fourth grade. And we've been at least, you know, our law has said that as long as the proof occurred that the incident occurred before the return of the indictment and within the statute of limitations, that should be sufficient, particularly when you have a minor and when the minor is still under the age of 14.
right, and the idea that we don't expect minors to be able to give exact testimony, give them that latitude. And
Right.
yes, I understand. The issue here is that there were 3 allegations, and as to the minor, yes, there are references to her testimony where she talks about grades, places she lived, but there's also testimony where she talks about not being able to say, to connect the specific offense allegation in the indictment to her testimony. So if I digress to the police officer and then I'll go back to the alleged victim. For example, the police officer testified to 2 timeframes when there were 3 instances without connecting the time frame to the instance. And as to the victim, she couldn't give testimony. I'm not going to say exact testimony, but she couldn't give, I would argue, sufficient testimony to say what happened when, in other words, to connect the 3 instances to a reasonably near time frame, and for a jury to be able to determine, well, was that testimony referring to the first charge, the second charge count 1, or the second charge count 3? And that's where I talk about the unanimity issue. And if those timeframes are not properly connected to the allegations by the evidence, then how would a jury be able to reach unanimous verdicts? And in those instances, the argument would be it's structural error regarding automatic reversal because he's deprived of his Sixth Amendment right to a unanimous.
Mr. Paris, I want to back up a bit here. I read your reply brief before coming in here again, and you continue to maintain that the time is an essential element of the case, and you argue it's because that's what that's the allegations in the indictment. Specific time periods, jury instructions supposedly allege that time was an essential element of the case. And but I hear you today, earlier this morning, in response to CJ Torres, that when he set out what the case law is in our jurisdiction in terms of so long as it's reasonably close to the time period alleged or prior to the date of the indictment, so long as it's within the statute of limitations. So before I analyze further in reference to your argument and sufficiency, are you moving away now that time is an essential element of the offense in this case?
No, Your Honor. I maintain that time is an essential element of the offense, and I recognize that the Campbell case said that it's not, but that proposition was qualified by the word generally. Generally, it's not. But what happened in this case, it was specific.
But you didn't, of course, cite any case for us to re-examine Campbell and Titano that set out so long as it's reasonably close to the time period alleged in the indictment or the alternative. And so if it's, are you saying that because the trial court and the prosecutor argued and made it such that time was an essential element, that in some way now the government is foreclosed from relying on case law that says otherwise?
Under the circumstances of this case, yes, because while Campbell said it's generally not an element, the qualifying word is generally, and in this case, time was made an element of the offense because that's how, in the indictment, it provides time, a time element. In the instruction 6A, B, and C, it provides a time element. The Attorney General, in arguments to the jury, recognized time as an element. And and that's what the defendant expected.
But our case law of, I think Campbell, although you interpret it a little more narrowly, and People versus Steino say that time is not a material element of these offenses. You know, taking into account the balancing act in terms of a child victim testifying under these circumstances and a defendant's right.
So
fair trial.
I mean, looking at it from the point of view of the jury, why are we being read an indictment that includes time? Why are we being instructed that time is an essential element? And a defendant, knowing that the jury is going to be viewing time as an element, is going to be relying upon the people's theory of the case that time is an element and these offenses occurred at these times, even under that kind of broad treatment in the court's prior cases like Campbell. In this case, time was specifically made an element.
Well, in my mind, Mr. Perez, I mean, it goes to notice. I mean,
yes,
in order for the defendant to prepare for trial and not be surprised. However, in this case, your client says, I didn't do it. And so there was no surprise element as to these periods of time or alibi defense that I wasn't present during these time periods.
But the defense is more than I didn't do it. The defense is I didn't do it, and you can't prove that I did it. And you can't prove that I did it because you can't establish. Your theory is that these things happened on within specific timeframes. And when we look at your evidence, you did not establish that, and you even acknowledged it in closing arguments. And the court told the jury that we would have to prove that, and that it is a notice issue. And when you're in trial.
Well, let me just say to that, I mean, if the government places a higher burden on itself that is sanctioned by the court, and that is how the instructions were given to the jury, and the jury still came back with guilty verdicts, you have not cited any case, and I'm not aware of any, that states on appeal, the government may not rely on case law as to how to satisfy the time element, which is reasonably near, or that it's prior to the date of the indictment, so long as it's within the statute of limitations.
Well, my response to that would be, number one, Campbell talks about generally. Number two, there's the issue of variance and whether or not the government's theory, whether they connected their theory of the case in terms of fact and evidence to what they've charged. And our other argument as to time is, well, you didn't do that. And because you didn't do that, the jury could not have reached a unanimous verdict. So it brings us to the variance issue and the unanimity issue.
So you don't think that the victim's testimony, testifying as to the incidents and tying it into first incident when I was living in Santa Rita, second incident when I was in the Orange home, and then the incident regarding the fellatio was at a specific place, and when I was, I guess she said the second was when I was in the third or fourth grade, and then the mother's testimony as to relatively what those time periods were, that there was still insufficient evidence to satisfy the standard, which is consistent with our case law of reasonably near or alternatively before the indictment within the statute of limitations.
So I guess the question, I'm understanding the question to me to be, well, did the evidence
Sufficient.
satisfy that? And the argument is no. And the further argument is, as I've argued before, in cases before this panel, it's just way too easy to get these convictions. And one of the ways to make these cases more fair is to hold trial courts and prosecutors to observe a defendant's rights or rights to.
So do you want us then to revisit the standard in terms of for child victims and requiring specific dates to be testified to and proven under these circumstances?
I think limited to the facts of this case, that it would be proper to remand this case for a new trial because of the way the time element was treated in this case by the prosecutor and by the court, and understandably and reasonably relied upon by the defendant. And the court, if it agrees with me, can do that by looking to Campbell. And
when you said, and because as CJ pointed out, it's a plain error standard of review. And so your argument, as I understand it, goes to the substantial rights that your client, the defendant in this case, was prejudiced in reference to the time periods not being established. And so how is your client prejudiced in putting on the defense and even if we were to grant you that shortcoming?
Right to fair trial, right to due process, right to
unanimity. But those are just generic terms. But what specifically could your client have done differently?
I'll connect it. Well, what he did do during trial, which was to argue the time element and to argue that the burden of proof was not met regarding the elements of the offense. And it was recognized by the AG in closing arguments.
But that only holds if we were then to change our position that time is an essential element of the offense.
But why doesn't that also just go to the weight of the evidence, of the uncertainty of the child as to the time or date upon which the offense was charged? And that's kind of why we recognize that in Campbell, is that, we can't expect children to have exactness with regards to date and certainty. And so if there is some uncertainty that exists with regards to that, and that should go to the weight rather than the admissibility of the evidence. So the evidence was admitted, her testimony on the first incident occurring when she lived in Santa Rita, the second when she was in the second or third grade, and the last when she lived in the Orange House. And then coupled with the mother's testimony, she seemed to at least set forth some timeframes where the allegations occurred. And I'm still trying to understand how your client was prejudiced or surprised by the dates that were set forth, or couldn't prepare an adequate defense, understanding that these were the dates that were set forth, and that these were the dates or generalizations when they were testified to.
It's more that these are the dates that were expected to be proved. And
so just because the government actually put it in the indictment, that they had to prove that those exact dates, is what you're saying?
Well, take the trial as a whole. That would be a factor. The other factor would be how the jury was instructed. Even go before how the jury was instructed, the discussions during the jury conference about what instructions would be given, and the actual instructions given, and the arguments that were presented. So I understand we're never going to win on the issue of you have to prove the exact dates. This court has been clear, you don't have to. So I know we're not going to win that. But is it fair to ask this court to look at how this trial happened, what notice was given to the defendant, what was told to the jury, and what effect would that have on the jury and on the defense, to look at whether or not his rights were observed? And I know that we all argue on appeal or in motion arguments these generic concepts like due process and fair trial, but this trial was conducted to treat time as an essential element.
But Mr. Paris, isn't time an essential element? Isn't what the age of the victim at the time of the offense
Yes. It is,
something the government has to prove?
it does. It
So
does.
you can't have an indictment that doesn't have the time in it, can you?
Well, also regarding statute of limitations. Right, because you have to file a case within the statute, and if you don't, then there's a jurisdictional argument about the propriety of that charging document. But I'm not sure if I'm understanding exactly where your question was directed, but yes, I think that in order to give notice, yes, in order to establish the element of a certain age, you have to establish timeframes.
But that's not the element of time that you're arguing.
Right.
You're arguing it's when the incidents occurred, the time of when it is, and that
yes,
the government,
that's correct.
the government has to prove that when it says it happened between January and April, that there is testimony to support that allegation, 2018.
But even if that argument is, even if I'm wrong on that argument, and even if it's because of the nearness, reasonable nearness analysis, it still needs to be connected, does it not, to the allegation? Doesn't the government have to connect in some way when you've got multiple allegations? Even if it's a reasonable nearness time frame to the offense?
I want to move to the other issues in the case because your time is winding down. And in terms of the police officer's testimony, the hearsay arguments, that the government's response, and you argue that this hearsay and that it should have been kept out and it's error to allow it, and it affected the verdict. And the government's response is the invited error and cumulative evidence. But in thinking more about your arguments, I mean, if we view it as being cumulative, is there still the risk of can cumulative evidence influence the outcome? I guess is what I'm trying to think about here. And so the government says, oh, it's cumulative, so it's harmless. But can cumulative evidence, if allowed if allowed to stand, influence, and there's a risk that it also can influence the outcome of the case?
Absolutely. And I would start by saying the government always argues evidence that shouldn't have come in was cumulative or otherwise innocuous. But yes, because for example, when the Attorney General was arguing in closing about how difficult the fact of time, whether we call it an element or the fact of time or the government's theory, they relied upon Officer Putras's testimony regarding time. And that was more specific than the alleged victim's testimony regarding time. And that's how they purported to cure their inability to establish time. So yes, whether it's cumulative or not, cumulative evidence, for example, in this case, has the ability to have that effect. And I disagree that the door was opened by the defense, or that this was an invited response, because on direct, people elicited substantive evidence from Officer Putras when they asked him, how did they hear about the investigation? He said it was passed down information of a criminal sexual conduct complaint at Carbolito School in Totu, and that he interviewed. Then he talks about who he interviewed: Dr. Gracia, PB, Jackie Vichy, Gomez, and then he identified the defendant as the perpetrator. So he was discussing substantive content when he testified. And, to make matters, if I go to the next issue, to make matters worse, we had Ms. Uggan admitted as an expert in general counseling. And my understanding of the rule regarding experts is, number one, it needs to be specialized skill or knowledge, and not general. And in this case, when you look at the record, the Attorney General backed off from a more specialized area of expertise in their request to admit her as an expert, and retreated to general counseling because
What about her experience, though? I mean, she had significant experience with these types of cases, and while she may not have had specific facts dealing with this particular victim and didn't interview her or anything, we've recognized in prior cases that a police officer can give expert testimony about delayed reporting because of his extensive personal experience with it regarding investigation of sexual assault cases. So here, I think she had counseled more than 70 or 80 sexual assault victims. She was a counselor for more than 10 years. And so she had the ability to, based on her experience, understand that, a significant percentage of these child victims delayed reporting.
Well, number one, I think in court decisions by this court talking about expert opinions, one of the things that has been said is just because somebody is an expert doesn't necessarily qualify them as an expert in a specific field, or separate from that means that they should still testify as an expert in a case. And there's the issue, first of all, she had this body of experience and knowledge, but she was qualified as an expert in general counseling. There was a disconnect between delayed reporting, which is what they wanted to have her admitted as an expert for, and general counseling. And the fact that it's not only that she didn't have knowledge, she testified to no knowledge regarding the case. She didn't know the victim. She didn't interview the victim. She didn't know if the victim was a client of Healing Hearts. She didn't know what the charges were. She knew nothing about the case.
The prosecution says that's a good thing because then her testimony didn't bolster the victim's credibility.
What was the purpose of the prosecution offering this? I mean, they pretend it's not for. They pretend it's.
I guess the argument is to assist the trier of fact to get an understanding of why the victim may have delayed reporting in this particular case.
But she didn't even know that the victim in this case had delayed. She didn't see one of the. When you have an expert, the expert is supposed to apply their expertise to the case. And that didn't happen here. She was merely offered to say, hey, if there's a delayed reporting, 70% of the time 70 or 80% of the time that happens, as if to suggest that the alleged victim's delayed reporting in this case was entirely natural, reasonable, typical. And in that sense, that's where we get to the area of improper bolstering and vouching, because it basically was to give credence to the delayed reporting in this case.
What was the rationale of the trial court in the second element of that it will be helpful to the jury, that the second element of the Rule 702 test? Do you recall what was the basis of the trial court stating that element was satisfied?
My general recollection was just regarding delayed reporting in general, I think. But I don't want to misstate what the record said. I think that's what it was for. I think that was the rationale. But
going back into the credentials, because People versus Roten, the reference to the police officer having about 15 years experience, we allowed that officer had sufficient experience to testify to the matters that he did in that particular case. In this case, we had Mrs. Uggan who had counseled about 70, as you mentioned, 70, 80 cases in terms of sexual offenses of child victims, and testified that about 70% of these cases they don't report it instantly. And so in lieu of our authority already that exists in People versus Roten, I mean, why wouldn't this be a similar instance? And what credential would you require for someone to testify on the issue of delayed reporting?
Somebody who was able to substantiate through, somebody would be able to establish their expertise in delayed reporting, and for the court to conduct a 702 analysis, that they're an expert in that field.
But wouldn't that be a counselor, can be a counselor who has interviewed about 70 similar type cases that through experience on the job, that they have developed a separate qualification from just an ordinary citizen who can opine on this topic?
I think that what's telling is the Attorney General's retreat from their proffer of her as an expert in that field to one of general counseling. They couldn't establish it, and the defense was persistent in its objections, so they retreated to the position.
So how do you distinguish this case with the Roten case, where we held that a police officer based on experience in the field qualified as an expert, and that's still good law as far as I know?
Each case has to be taken on its own, and we have to ensure that that the facts of the case satisfy Rule 702, and maybe an argument could be made that if she had been certified as an expert in delayed reporting in this case, and I was arguing it on appeal, then the court would be in a position to determine whether or not that was an invalid area to establish her as an expert. But in this case, general counseling, does that rise to the level of the specialized knowledge and skill? And then to me, the more troubling issue is, she didn't apply anything from this case to her purported expertise, which leaves the impression that she was offered simply to lend credibility to the.
But if she did, say, for example, she was informed of the facts of the case, and she then opined based on the child victim in this particular case and a delayed time period, wouldn't then, as the government seems to imply, then wouldn't that also then be supporting and vouching for the witness's testimony?
That would be, the AG has the burden of proof. They want to offer an expert. They need to do it properly. And this goes to my overall argument about how important it is that in these types of CSE cases where there's no corroboration required, where you've got a protracted statute of limitations, and where alleged victims don't establish through their testimony the elements of the offense, that we need to be particularly careful about holding the prosecution to and protecting a defendant's rights when it comes to experts, hearsay testimony, and other protections that are put in place to make sure that they receive fair trials. And I think my client has nearly a 20-year sentence. Another CSE defendant where arguably their rights have been disregarded casually, or not by this panel, but where by perhaps the AG, or it just seems like defendants' rights are just too casually treated. And we have these decades-long sentences for these defendants.
I don't disagree with your general principles, Mr. Paris. But, in terms of the standard of review, we are not deciding guilt or innocence. The jury is the one that made that decision based on the presentation of that evidence. And we're just looking at these narrow parts as to whether or not your client received a fair trial.
And I would ask the court to find plain error regarding the hearsay. I'd ask the court to find an abuse of discretion regarding the expert, and I would ask the court to find structural error regarding the time issue. Alternatively, plain error or harmless error where it may apply. But I think structural error would apply on the unanimity issue.
You've exceeded your time by 3 minutes already,
Okay.
Mr. Paris. The court will give you 2 more minutes on rebuttal, though.
Okay,
All right?
thank you.
Additional time. So plan to use that wisely since you only have 2 minutes. Ms. Santos.
Good morning, Mr. Chief Justice, and may it please the court. This is a case where a minor child was sexually assaulted by a male known to her when she was 2nd, 3rd, and 4th grade, and she was testifying at the trial when she was in 8th grade. As to the first argument that time is an element of the offense, the Attorney General did not concede that time is an element of the offense by putting it in the jury instructions. The jury instructions are necessary to avoid the unanimity issues that appellant brings up later in his reply brief, because absent that element, then they would appeal on the basis of we don't know the time period and we don't know whether there was a material variance because the dates were not told to the jury.
Ms.
So-
Tenorio, don't you have to prove the time?
We have to prove the element of under the age of 14 years, but we don't have to prove the exact date. So in this case, she was under the age of 14 at all relevant periods, including when she was on the stand. So the way that's explained to the jury is that proof need not show the exact time of the crime. It just needs to be shown on or about as long as we meet the element of under the age of 14. So as in Campbell, when the people charged the indictment June or July of 2001, and the incident at the trial proved that it was any time in 2001, this court has held that that was sufficient and there was no material variance on that issue. Now,
But didn't at closing, the Attorney General concede that the essential element of the time frame for the charged offense was problematic?
so when the prosecutor said that we're going to have difficulty in the time range, that's signaling to the jury that, one, we don't have to prove the exact time there, but that the difficulty in the time range was merely because the victim herself could not remember certain dates, but that's why he referenced other testimony by different witnesses explaining that even though the victim herself would not be able to say these exact months and years, that you can use other people's testimony so that we know that this occurred generally during this time period. And again, we have to do it that way so that there are no unanimity issues. And that's the way we give notice to both the defendant and then also signal to the jury of what we're trying to prove below. Also, how to differentiate the acts to avoid unanimity issues on appeal. The reason why the dates are given the way they are is so that we can refer to them in general. When we talk about this charge, this is this incident.
What about the overlapping timeframes, though? I mean, Mr. Paris argues that in his reply brief that the January 1, 2018, August 1, 2018 on the first charge, and then on the second, you have April 1 and December 1, 2018.
There is no danger of unanimity issue there because there's to-wit language in each of the charges. So for the overlapping dates, the dates did not overlap for the 2 touching charges. The dates only overlap for the first degree CSE, but that was specifically fellatio. The second degree CSE count where he says that it's overlapping, it specifically says touching the primary general area of the victim. So the jury would not have been able to confuse those 2 different acts because they were always referred to in the trial as 3 separate acts. The prosecutor kept referring it to as the fellatio incident, the Sanarina incident, and then also the Barragata incident. So while time and location are not elements of the offenses, that's how you explain to a jury the specific acts. And under Campbell, as long as a child victim is able to describe the specific act themselves, which she did, and then describe the general time period, and as long as the defendant is not surprised, which he could not have been because it was very clear that the to-wit language showed what acts were being referred to, then there is no material variance on that issue. So under a plain error standard of review for the material variance issue, the appellant did not, his substantial rights were not affected, and there would be no miscarriage of justice because his defense was not that they didn't happen during these periods of time. And the closing arguments in the case made by the defense counsel largely rested on the victim's uncertainty as to the dates. So while that does not go to the admissibility of the evidence, it goes to the weight of the evidence. And in this case, the jury weighed in favor of the people, even given the whole closing arguments that, she could not remember the exact dates. And this court has said that goes to weight, not admissibility. Now,
what about Justice Carbolito's question of the Officer Putress's testimony regarding the timeframes, which, obviously the government concedes were hearsay. They say it was a for another reason. And that you also argue that the testimony is cumulative, but could that evidence have although cumulative, have prejudiced the defendant?
I don't believe so, because even excluding that question, which again was invited by defense counsel on his cross-examination, the issue with that question was the defense counsel elicited the wrong information. So the prosecutor had a duty to correct the misremembering of the date, and that was why that was done. Now, I understand the prosecutor used that in closing argument to say that this had proved the date, but my argument is that even excluding the officer's testimony, it was cumulative because we had already established in the record by the victim, the mother, and the defendant himself, the time periods that they are living in each of these locations. So I do think that in cases where hearsay testimony is omitted cumulatively about the substantive acts, that may, I think very rarely, but may influence the verdict, but not in this case because the time periods were very general. And then also, if you think about the rulings by this court, that as long as reasonably near can be up to 2 years. This court has held up to 2 years as long as the testimony comes out that it's reasonably near, then it suffices. In this case, even if Officer Putress didn't clarify that it happened in January or February of 2019, the jury was given her birth dates and the grades that she was in. And given that she was in 4th grade at that incident, the jury could have found that was August of 2018 and on, which would have established that charge, which the dates were January 2019. So if she said 4th grade, and then they could calculate the days, just actually by her very testimony alone, not even including her mother or the defendant or the teacher, Miss Gracia, there would still have been sufficient evidence as to the time. But again, the government's argument is that the defense opened the door to that testimony, and exactly what happened. And I think in People v. Callahan, this court has stated that when a defendant elicits a question, whether that elicits an inaccurate answer, the people were allowed to refresh that witness's recollection. They were allowed to clarify any confusion. Now, as far as the testimony of Miss Maria Teresa Uggen, or Marissa Uggen. Now, Miss Uggen was admitted as an expert in counseling in general, and under Rule 702, all that is expert testimony is admissible if that it would assist the trier of fact and if the person is qualified via knowledge and experience. This court has held that an officer in Rotin was qualified by experience and training to render his statements about delayed reporting. In this one, she was a licensed, in this case, Ms. Uggan was a licensed professional counselor with over 10 years of experience, over 700 therapy sessions, and over 70 clients of sexual abuse. Now, this would assist the trier of fact because in cases like this in criminal sexual conduct, there is a common misunderstanding that children who have been sexually abused would report right away, and they would tell a authority figure right away. So Ms. Uggan's testimony was general testimony about all the reasons that she has encountered through her training and experience why victims don't report right away. And she wasn't applying it to this case specifically to avoid bolstering. She didn't say, and because I know that this is one reason victims don't report, then therefore this victim is not lying. She didn't know anything about the facts of the case, and the prosecutor elicited that during her questioning, her direct examination. So again, there's the case law that I cited in my brief. Many jurisdictions offer this type of expert testimony to explain what may be construed as inconsistent behaviors that would affect a juror's assessment of credibility, and to rebut any defense argument, which I do think they made the argument in this case that if this happened, she would have reported immediately. She did not report this till the 5th grade, even though this had started happening in 2nd grade. So again, general testimony is preferred, and this court has held that under Roten, that as long as the expert does not opine on the credibility of the witness, then it wouldn't be considered error. And then I did, so under a harmless error standard of review, the people assert that there is no error in admitting her testimony. And even if there was, because they think the defense argument is that she needed to have specifically studied delayed reporting. I think that is an incorrect argument. In People v. Santos, this court has held sexual assault nurse examiner who has engaged in hundreds of sexual assault nurse examinations. That's she didn't necessarily have to study or have some very specific training or credentials, but in that particular instance that she was qualified as an expert in this case. There is no expert that is available specifically in delayed reporting. It is by virtue of experience. And as this court has held in People v. Roten, the facts relied on to come to the conclusion, her conclusion that 70% of child victims delay reporting, that establishes her expertise and generalized knowledge in this case. Now, I want
to go back to the questioning, just listening to what you're saying about the expert, and in reference to that the testimony would be helpful to the jury in this case. So what was the specific finding that the Superior Court based its decision on and how it would be helpful? What was the basis that the Superior Court advanced to satisfy that second element in this case?
So the record showed that the Superior Court relied on this court's finding in People v. Roten that a testimony on delayed reporting specifically assists the trier of fact. There was no, that was the general discussion of that matter. There was no, the prosecutor had put forth that there would be evidence that this victim delayed reporting, and so it would assist the trier of fact in helping them understand what the different reasons are that victims delay reporting.
But there was no reliance, there was no opinion given based on the facts of this case.
Right.
So how would it be helpful to the jury if, in fact, there was just some general testimony? If there was going to be no specific basis based on the facts of this case in which this expert opinion was to give testimony?
So general educative testimony has been permitted and in different jurisdictions with specifically regarding delayed reporting, again, to avoid the bolstering issue. Because if Ms. Uggan had stated her opinion as to the credibility of the victim, that would automatically be bolstering and an appealable issue. So in this case, it assists the trier of fact because the general juror does not have experience with sexual assault victims or child sexual assault victims. So it gives them knowledge which they can use for themselves to render a verdict. So so there would be no danger in saying, because Ms. Uggan stated that this occurs, then I believe her because she's an expert, so that I will find this defendant guilty. Ms. Uggan, all she did was give facts based on her experience in the field, and then the jurors were left to figure out for themselves whether that they applied in this case or not, coupled with their assessment of the victim's credibility in general. And again, when the defendant puts forth in his all his briefings that the victim could not recall the certain things because which goes to the insufficiency of the evidence. When this court reviews sufficiency of the evidence, you look at what was in the record, not what she wasn't able to do. You look at what she was able to recall, and they're very specific grade ranges and locations that she had described as occurring in all of these places. And so the sufficiency of the argument fails, and the government did not fail to prove the dates or the evidence as to the dates. As discussed earlier, all dates in question would have been when the victim was under the age of 14. And again, the defendant himself helped establish those date ranges through the testimony of Officer Putris. That is why Officer Putris was called as a witness. And so back to the time element, again, I want to emphasize that because the jury, even though the jury instructions contained the recitation that these are the elements of the offense, we cannot omit the date in that portion because the jury actually has to make a finding of a range of dates that it occurred in order to avoid any unanimity issues. So unanimity, that would only have been an issue in this case if there had maybe been multiple showings, like maybe 5 incidents with the time frame, then there may be a unanimity issue. Some courts have recognized that there is not, but we're not talking about that at all. It was very specific instance, very specific date ranges that this occurred. And while a defendant appellant states that he did not receive a fair trial, the record shows that he did receive a fair trial because all of these arguments were made below, that she did not report right away, that her testimony had changed. And I do want to go back to Mr. Perez's argument about the distinguishing between the first and second incidents. So it actually was elicited at trial that the officer only ever was told about 2 incidents. So officer's testimony actually went to impeachment purposes, setting aside the date issue. It went to impeachment purposes because the 3rd incident of the fellatio did not get elicited until later in the case to different law enforcement. So the jurors were actually able to take that into consideration. So when Mr. Perez cites, well, there are overlapping first and second incidents, it's because he was never told about the fellatio incident, and that came out before. And it was also elicited during the teacher's testimony. The teacher's testimony was that she had said the victim had testified that she was touched 3 times. But again, in the charging papers, we only charge touching of the vagina twice and then fellatio once. So all of those things go to a fair trial with the defense. He was able to take this all and argue these failure of recalling the dates and inconsistent statements to the jury. But at the end, the jury did find in favor of the people and found him guilty of the charges beyond a reasonable doubt.
I have no further questions. Any further? Thank you, Ms. Santos. Mr. Perez,
Thank you.
2 minutes.
I think I would just respond to the issue of Ms. Uggan and say that, first of all, it's acknowledged that she had no personal knowledge regarding the victim at all. And so what was she offered for? I thought what was very telling in Ms. Tenorio's argument was it was to assessment of the victim's credibility. But isn't that exactly what bolstering and vouching are? And that appears to have been the purpose for offering Ms. Uggan in this case. If she was an expert in delayed reporting, why wasn't she admitted as an expert in delayed reporting? That's all I would say.
All right. Thank you, Mr. Paris. Thank you, Ms. Santos. The court will take the matter under advisement, will issue a written opinion, and will now stand adjourned.